Look, this is the most polarizing issue facing the country. The rail blockades in support of some of the hereditary Wet'suwet'en chiefs who oppose the Coastal Gas pipeline in British Columbia. Are the blockades helping or hurting the key issue of reconciliation? We debate this today, and we're launching a new series called Power Play Face-Off, where we invite two players to debate the key news of the week. Today, Mi'kmaq lawyer, professor, and the chair of Indigenous governance at Ryerson University, Pam Palmater, is here. She's in Toronto. She does not like the pipeline and supports the protests. And then a BC Liberal MLA and a former chief counselor to the Haisla Nation and a pipeline supporter, Ellis Ross, joins us. I really appreciate both of you joining us on our first edition of Power Play Face-Off. And Mr. Ross, let me just start with you. Can you make the case, in your view, why you believe these protests are harming reconciliation and why you believe this pipeline should be built?
Mainly because reconciliation has been happening ever since 2004. The Haida court case that came down that actually laid out the rules on the consultation and accommodation measures that the Crown had to uphold. And so for 15 years, we've been signing agreements with the provincial government, the federal government, as well as with proponents in forestry, as well as LNG. And that extensive consultation record was mainly, to lift ourselves out of poverty, give the next generation a better future than what I had or my parents had, but also to breathe life into Section 35 of the Constitution. So yes, we've been reconciling Aboriginal rights and title for the better part of 15 years.
Wow. Well,
Professor Palmater, go ahead.
Yeah, so many First Nations, grassroots citizens and traditional governments would completely disagree with that. The way Section 35 has been interpreted has been a huge problem. And in many of these cases, you look at the BCTC process and all of the access to information documents that we received, where both BC and industry never had any intention of recognizing native land rights. It was really just the push for these agreements, the pressure saying you don't have an option, these things are going to be built, you better take it or leave it. Sometimes the communities don't even get a say in this, and this is exactly what's happening here. You had one community in the Wet'suwet'en who had a referendum, and the majority said no. They did a survey in another community, the majority said no. You have hereditary leaders who aren't just representing themselves, but literally hundreds of clan members who are saying no. So there's clearly no agreement in that nation. So Coastal GasLink has no authority.
Okay, let me give Mr. Ross a chance to respond to that. Go ahead, sir.
Yeah, what are you talking about? The question was reconciliation. You brought in the BC treaty process that my band pulled out of on the day I became chief counselor, because I want independence. I want a better future for my people. This is what a lot of leaders don't talk about. They don't talk about the suicide rates or the children going into care. All they worry about is their organizations that get more money for lawyers and themselves to give themselves a comfortable standard of living that I'm fighting for my people to have. Even half the salary some of these leaders are making, so that we can live in colonial houses and get their pension plans and get their salaries and their cars and their trucks. So hypocritical for these leaders to be talking like this when the majority of First Nations are living in poverty.
Wow, I haven't heard any of the hereditary leaders or traditional leaders talk about any of that stuff.
Of course you haven't, because you haven't talked to members.
And many of them don't even get those salaries. And if you're talking about First Nations chiefs and counselors, the statistics have already been done about their salaries, and they make less than the average Canadian.
Hold on.
They make less than municipal librarians.
Raise your voice, sure. Talk about these organizations, but never mention poverty that First Nations are suffering under. Go ahead, keep it up.
Okay, let me just hear Pam Palmater first, and then I'll go back to you. Go ahead, Pam Palmater.
Well, I mean, if we're going to talk about the issues and vilify First Nation leaders, then we have to talk about the statistical facts. A report was already done that showed the average salary of First Nations leaders and councillors was less than the average Canadian, less than municipal librarians. And if we're talking about hereditary leaders and traditional leaders, who are the ones that have the legal jurisdiction over these traditional territories, many of them don't make any income at all. They're following their traditional laws, and they're not employed by the bands in those ways. So, I mean, that makes no sense what it is that he's saying.
Okay, let me just move this back to one issue, and I'm going to start with you again, Ellis Ross. Does the law, a lot of the protesters in solidarity of the hereditary chiefs who are rejecting the pipeline say that the hereditary chiefs have jurisdiction over hereditary land. They cite the law to support them. They say the elected chiefs only have jurisdiction over the reservation lands. What's your take on that, sir?
So mostly what I've read is that they take the court case of Delgamu and they apply that principle that the hereditary chiefs took that court case and won it. But if you take that logic that basically says whoever takes that court case and wins it actually has jurisdiction, well, my band intervened in the Haida court case on the duty to consult and accommodate, and we won. It was our elected chief and council. So by that same logic, does that mean that the Crown has to consult and accommodate elected First Nation leaders only and not hereditary? There is no principle in case law that I ever saw that says hereditary leadership has jurisdiction off reserve lands and elected leaders have jurisdiction on reserve. I've never seen it in case law. If anything, people are taking the principles of case law and taking it out of context. They're not taking the whole case law as a whole.
Oh, wow. Well, I mean, the law is pretty simple in that regard. We're talking about
I haven't said wow once to your comments.
Okay, anyway, the Indian Act has very specific legislative jurisdiction for band councils, what they can and can't do, what their governing limitations are, which is why so many First Nations are against the Indian Act. They have very limited bylaw making powers. It's only over the reserve lands. Over the traditional lands, that legal authority is long recognized as investing in the nation,
I'm not against the Indian Act.
not the individual band councils. And this is the issue with the Wet'suwet'en. It's the Wet'suwet'en leaders and the Gitxsan leaders that went through Delgamu.
No, it's not.
It was recognized by all of the parties, federal, provincial, industry, and the First Nation leaders during that time, that they're the ones that had the authority, or the case never would have advanced that way. So the law is very clear in that sense.
All right, hang on again, and I know that, and we've talked about this a lot, the Delgamu case of '97 and the Chilcotin case of 2014, which are frameworks around this, and it's debating. But again, I just want to get back in the last minutes we've got on our power play face-off. Again, I'll go back to you, Ellis Ross. You support this pipeline. Again, the solidarity protest, they say we are in solidarity with the Wet'suwet'en hereditary chiefs, and we are standing up for the rights of Indigenous peoples and helping the cause of reconciliation. Do you think the pipeline protesters and the blockades are helping reconciliation, and that blocking this pipeline would help enforce Indigenous rights?
No, they are misinformed, because as chief and council, what we did in 2004 is we were the ones that stood up for our own Aboriginal rights and title in the context of consultation and accommodation. 20 bands from Prince George to Kitimat did the same thing. The Gitgat did the same thing. They stood up for their Aboriginal rights and title, and the consultation and accommodation process kicked in, and then we had accommodation for the infringement of our rights and title. But we did it for a reason. We wanted to resolve poverty. I mean, you listen to some of these stories that some of these people are telling. They had the Moose Hide campaign in front of the legislature yesterday. And this woman got up and said in her own community, she was sexually abused from the age of 4 to the age of 12, and then she started running away. This is the violence of poverty. Nobody is talking about why these elected councils are doing what they're doing. They're trying to get away from this. And I could care less about the Indian Act. In the face of opportunity, given the Aboriginal rights and title case law, we've got a chance to build a better future for our people. This is the main point everybody's missing.
All right, Pam Palmater, I want you to respond to that. Elected chiefs in the Wet'suwet'en, other nations like the Haisla Nation want this pipeline. They are saying this is going to give us economic opportunity. Why is that voice not being heard?
Well, that voice is being heard loud and clear, and that's why all of this has happened. All of those arrests have happened. I mean, so there's no silencing of the pro-pipeline folks, but you cannot come up with an anti-poverty strategy that is based on destruction of the climate for all peoples for all times.
Come on.
I mean, that is just not
I thought this was going to be a legitimate debate.
And that is not based on Indigenous laws or Indigenous concepts around sustainability. And we have to remember that it doesn't matter whether there's 20 First Nations or 100 First Nations that agree to a certain economic opportunity. It's within each traditional nation to decide what happens on their territory. And there is no consent within the Wet'suwet'en Nation.
All right, listen.
Unbelievable.
I know this is a passionate debate. And I got to tell you, Pam Palmater and Ellis Ross, I know obviously we didn't resolve a lot, but we heard a lot. And I really appreciate listening to both of you. I really thank both of you for joining us today. And I hope we get a chance to keep this conversation going. Thanks to both of you very much.
Evan.
Thank you.
Thank you.